The Court of Appeals is now in session.
Good morning and welcome to the Court of Appeals and virtual session. In what I think will be the waning days of us routinely holding our hearings virtually rather than in our courtroom. It's been ascertained that all counsel have participated in one or more of our virtual arguments, and the clerk of court has ascertained the rebuttal time and reminded everyone about turning off their video, and that we'll be raising our hands when we hope to be recognized for a question, etc. So as far as I'm concerned, we're just at a point where we can have counsel state their appearances for the record, and then we'll turn to appellant's argument. If counsel would do that, please.
Martha Pierce, attorney guardian ad litem for the minor child.
John Peterson, Assistant Attorney General for the state of Utah.
Shelley Harding, appearing for CS, the father.
Very good. Thank you all. Ms. Harding, we'll hear your opening argument first then.
Good morning, judges. This is a little unusual, but I'd really like to start with a question of you. And that is because when we're told that we're going to do full briefing on a case, we don't know what the hot issues are. We may suspect, but we don't know. And I don't want to launch into stuff that's totally irrelevant. So I wondered if it was the right to counsel was one argument. The ICPC is what I'm guessing you want to hear about. But, you know, there could be also other parts of the full briefing.
Those are the two that were of particular attention to me, and maybe in that very order. I think the right to counsel, although it's been discussed at some length in the brief, speaking only for myself, that's kind of what caught my eye as being potentially quite significant in this case. So if you would start with that, I, for one, would appreciate it.
Certainly. I will start there. I just want to add, Judge, that the ICPC issue is huge for parental defense and for really everyone in juvenile court. There is constant debate about whether there's applicability of the ICPC, and it delays placement with parents for anywhere from 2 to 3 months to 9 months to a year. I've got a case coming up on a year where the ICPC is not done. So I think we often view that as our hottest issue, but definitely the right to counsel is a big issue in this case. And the real problem, of course, is that the father did not get an attorney until 2 weeks before permanency. So he went for almost a year without counsel. That means he had no one to object to the adjudication of neglect with no allegations of current neglect. And that was interesting because the court later in the termination said it was a dependency finding, but it was actually a neglect finding. And that's something that could have been appealed. And in the Buck case that I cited to you, that was very persuasive to that court, that there was an important proceeding with appeal rights, and he didn't have an attorney in that proceeding.
Ms. Harding, what do you make of the fact that that your client, at least the first 2 times he appeared, the record appears to indicate that he waived his right to counsel?
Okay. I think my clients are not sophisticated enough to know what rights they're giving up. It's often the first time they've been in juvenile court. They don't know how an attorney can help them. They don't want to slow down the process. They don't want to make the judge angry by saying, well, we can't proceed right now. We have to get an attorney. They have to negotiate all of those issues. And so with a very incomplete understanding, they're saying, oh, well, I guess we should just proceed. Which kind of takes us to the other point, which is, you know, the judge kept,
Ms. Harding, yes. Can I just, and I guess it's more of a sort of a rhetorical question, but isn't the logical extension of that, you know, that parents are unsophisticated and really don't know what's going on? Isn't the logical extension of that regardless of whether or not somebody wants counsel or waives counsel, the juvenile court judge should just appoint counsel pro forma? Is
That's
that
typically what happens.
you're asking?
Yes, that's typically what happens. So the way we do it most of the time in juvenile court is the court tells everyone you have a right to counsel. And would you like counsel? And then on the record, they'll say, do you qualify? What's your income? What are your expenses? They do it really quickly. And most of our clients do qualify. And so the vast majority of the time someone is appointed. And so we have counsel right away. So in addition, there was no attorney present for the to establish paternity. That was a critical issue that got missed in this case. So as you probably know, I was appointed for the appeal, was not present for any of the proceedings below, but there was, but that issue was missed by the attorneys who were subsequently appointed, and it should have been addressed very early on so that he could establish paternity and have rights to this child. By the time he got to trial, it would have been pretty difficult, even if anyone had noticed that he needed to establish paternity. He had no attorney to object to an ICPC, and that should have been objected to because by its terms, the ICPC does not apply. As you know, there's a split in the jurisdictions, but we believe, the parental defense believes it does not apply. He missed all the child and family team meetings. So that's where the cases really get worked on, is those monthly meetings where we're talking about how often are you seeing your child and what are the barriers and how can we fix this and how are you accessing services. So he had no attorney to guide him through that process. And an attorney at that point would have realized, I would hope, well, you haven't established paternity to this child either. And we better work on that aspect. And are you having trouble with this ICPC? And how can I help you with it so it doesn't linger on for months and months?
Ms. Harding, can I ask you about Utah Rule of Juvenile Procedure 35?
Yes.
That seems to give the court the option of either doing as you ask, which is, examining the parent on the record about their indigency status, or alternatively, sending them a form and telling them to fill out the form and send it in, indicating how much money they make, etc. The juvenile court appeared to pick the second option in this case. He, at least from what I can tell from the record, the court did early on in the case send the form to your client, and then the minute that your client indicated that he had filled it out and sent it in, counsel was appointed. What do you make of the argument that the juvenile court judge was proceeding under option 2 as laid out in Rule 35, and why do you think that was incorrect?
Well, I think that could have happened at the very beginning of the case, but once it became evident that the father was showing up for hearing after hearing without counsel and going to child and family team meetings without counsel, then clearly that was not working. So for a lot of my clients, if you email them something, for example, they can't ever print it out because all they have is a phone. And getting something back is often to the court is difficult for them as well. A lot of them don't know how to scan things and they don't know how to get documents back. So it often creates a barrier, is what I'm saying. If you have someone there in person, that's a lot easier. You can give them a paper and they can fill it out, and that's how we used to do it. But since things have become virtual and this is a parent in another state, it just adds delay and barriers. So I would say that if the judge got an affidavit back quickly, that would be an appropriate way to proceed. But to go hearing after hearing after hearing without the affidavit and allowing that to languish, I think that was inappropriate.
And one more question on this before I do want to get to the ICPC issue. It appears that you acknowledge that plain error is the standard of review we should apply here, and that's what you indicate in your brief. Do I have that right?
That is right. It wasn't raised below. Okay, if I can move on to the ICPC. Essentially, I think this court is presented with a very important issue to all of us, and we are certainly hoping that the court will address it. There are two different ways to approach it, as I'm sure you've seen. But I think that there's a growing movement in the states to state that the ICPC does not apply to the placement of a child with a parent. So the ICPC in Article 3, sub A, says that No sending agency shall send into any party state any child, and here's the important part, for placement in foster care or as a preliminary to a possible adoption, unless the sending agency complies with the ICPC. So what the states are saying is a parent in another state is not a placement in foster care, and it's not a preliminary to a possible adoption. Also, in the case of Emmanuel B., which I cited in my brief, 175 AD 3rd 49, 2019, it lists some of the legislative history. And it states that there is, they don't have paragraphs, but it's page 56. There's also nothing in the language of the statute or the legislative history to indicate that the ICPC was ever intended to address any individual other than an out-of-state foster or adoptive parent. The language explicitly limits its applicability to out-of-state placements in foster care or as a preliminary to a possible adoption.
So, Ms. Harding, can I break in there and ask you? So I think you've established that there's definitely a split in the states that have looked at this, and some states definitely go your way on this, and others don't.
Mm-hmm.
And when we have a situation like that, well, let me back up. Do you? I think from your brief, I understood that this issue you're asking us to review for plain error as well. Correct?
Correct.
And so when we look at something under the plain error standard, we're not just looking whether there's error, we're looking whether there's obvious error. And we have a fair bit of case law, including a case Judge Orm authored just last year, indicating that where there's a split of authority like that, it just is by definition not an obvious error for the court to go one way or the other if there's a split of authority like that. What's your response to that in terms of our review of this for plain error and given that there's this split of authority in the states?
The statute is really clear. It's obvious. It says it's for foster care or for placement for adoption. And where you have a statute that is really clear, I think you do have a basis to consider it. They're looking at Regulation 3, which includes parents, but where a regulation conflicts with the statute trumps it. We all know that. And this statute, because it's clear in its terms, we're saying it's error to have violated it.
Okay, I appreciate that answer. Let me ask you another question about this situation. So let's leave ICPC out of it for a second, and let's just look at a series of Utah statutes indicating that when we have children removed from a custodial parent's home by DCFS, and there's another non-custodial parent out there who seeks placement, the court shall place the child with the natural parent who requests custody unless it finds the placement will be unsafe.
Right.
And then the next section of that same statute says that the law requires the court to make a finding regarding the fitness of the parent described in the previous section to assume custody and the safety and appropriateness of the placement, including at a minimum ordering the division, which would be DCFS, to visit the parent's home, comply with the criminal background check, and check the division's management information, et cetera, et cetera. I'm reading the statute now.
Right.
But the point is, it doesn't appear to me that under Utah law, there's an automatic right for someone in your client's situation to get custody unexamined or get placement unexamined. The court's under an obligation to at least, let's say that your client was in Utah, the court would be under some sort of obligation, it would seem to me, to at least check out your client's house to make sure that that would be an appropriate place for the children to go. And so with that sort of Utah statutory obligation on the court, what's different if your client's in Louisiana as opposed to Utah? Isn't the court still obligated to do some sort of home visit?
Sure it is.
So tell me how the court erred by asking the Louisiana authorities to do the home visit in this case, in the court's effort to discharge its obligation under the Utah statutes.
Sure. The answer is that an ICPC can take 9 months to a year versus having our AG do a background check. They can do all those background checks, the criminal and safe checks, and then ask for a courtesy check from the other jurisdiction under Regulation 2 of the ICPC. So you could do all of that in a week or two versus an ICPC in California, they take 9 months routinely. And in other states, it can be 3 to 5 months. And as I mentioned earlier, I've got one that's almost a year now. So we're talking a couple weeks versus up to a year. That's the difference. Sorry. Judge, are you saying something to me?
Sorry about that. We've been doing this for 2 years. You would think we would know when to unmute ourselves. My bad. I didn't see anything about this courtesy check in your briefs, and I'm intrigued. So can you tell me more, if you know, about what a courtesy check involves and whether it would meet the standards of the Utah statutes here that require the court to do some investigation of your client's home?
It actually was in my brief, but I think I cited the wrong regulation. I think I cited Regulation 3, and I believe it's Regulation 2. So it's a courtesy check outside of the ICPC. I don't know a whole lot about how it works. I just know that the process exists and that DCFS can request a courtesy check in another state. It's just not the full-on investigation of an ICPC home study, and that's what becomes very lengthy. So it's a quicker process, but I don't know how it works.
All right, one final question for you. I know your time's up, and with Judge Orm's permission, if I could ask one more question. Your argument is that the ICPC by its terms doesn't apply if the person in question is a natural parent, and I understand that argument, I think. But with regard to one of these children, your client had not yet been adjudicated a parent. And with regard to that child, isn't your client functionally in the position of a foster placement or some other non-parental placement, given that his parental rights to KS weren't yet established?
Yes, through error. That should never have happened. That should have been resolved very early in the case before any sort of ICPC. But yes, that's true. Technically, he had not established himself, but that again should never have happened. He should have been established at the first or second hearing. You can do that by testimony of the parents, and we do that all the time.
Judge Christensen Forster, did I correctly glean that you might also have had one last question? Okay, very good. Thank you, Ms. Harding. We'll see you back on rebuttal in a few minutes, and in the meanwhile, we'll hear next we'll hear next from Ms. Pierce.
May it please the court, Martha Pierce, attorney guardian ad litem for the minor child. The correlative of parental rights is parental duties. And in this case, father was very content in being a passive parent. And sometimes that's okay if you have other people taking care of the child. But a child who is in foster care cannot have a passive parent. So let me address first the right to counsel issue. Ms. Harding is really attacking Rule 35, and she's really talking about best practices rather than judicial error. So there's no question that the judge complied with Rule 35. And under BYU versus Tremco, we have to assume that that is constitutional, that protects constitutional rights. So this court isn't here to say what best practice is. This court is here to say, do we have judicial error? And I don't think you have that, because the court did comply with that. And this was a very passive father who was content to just take a back seat when his child needed someone to help him out. If there's no other questions, I'd like to move on to the ICPC. This is the wrong case to litigate the ICPC, because it's only an issue if Ms. Harding can argue that but for the ICPC, the child would have been placed with father. And anyone who spent 5 minutes with the child would know that that simply could not happen. And Judge Harris is correct to say you need to do some kind of a background check on this other parent. She can't argue that. And there's a lot of case law on the ICPC. And in a footnote of my brief, I divide it into 2 categories. And the 2 categories show that this is the wrong case to litigate the ICPC. There's a group of states that say it doesn't apply when the parent has the parental presumption. And once you're within juvenile court jurisdiction, you no longer enjoy the parental presumption. Then there's another group of cases that says, well, the ICPC does a background check, but the ICPC doesn't decide where the child goes. That really is a judicial decision. the judge ultimately makes that decision. And again, if the judge or anybody spent 5 minutes with the child, they would never place the child with the father. He doesn't want to see his father, doesn't want to talk to his father, did not want the parenting assessment. If you read any part of the record, the part to read is the testimony of the child. He's very clear about what he wants, what he doesn't want, and what his experience is. And if you have a chance to read any other part of the record, I would recommend reading the testimony of Mrs. R, the one who took over his care. She was a principal, and he was disruptive. He was a problem child. He had conduct disorder, and they had a meeting to decide what they want to do with this. And the principal stepped up and said, I'm going to get licensed. I'm going to be his foster mother. I mean, it's an incredible story. It's a wonderful story. And this is where he wants to stay. And I think this court should respect the child's wishes and the child's lived experience.
What can you tell us, Ms. Pierce, about the difference between a courtesy check under Regulation 2 and an ICPC home study under Regulation 3?
I think the courtesy check is when the parent retains the parental presumption. Then you just need someone to do a quick walkthrough, and then we're good. If there's a reason to believe that there's something more going on, then the judge needs to do some kind of a background check. And even under our shelter statute, you need to do more than a courtesy check. It requires a background check to place with a non-custodial parent. So the judge has no other vehicle to do the background check, except for there's other ways he could do it, but at a minimum, you need a background check. And you need to talk to the child. And if you talk to the child, this wouldn't happen.
Well, as I read the statute, you need a background check and you need a visit to the parent's home, right? So
Right.
know, I think what Ms. Harding's arguing is, well, you can do a background check remotely. You could do a background check on somebody in Louisiana from Utah, but you can't visit their home from Utah. You need somebody in Louisiana to go do this. And I guess the argument being made today, which I didn't fully comprehend from the briefing, is, well, there's a truncated way to do that that doesn't involve a full-blown home study by Louisiana under the ICPC. And
Okay.
I don't know, do I have that right?
Well, yeah, that can happen, but in this case, nobody asked for that, so you do not have judicial error. Yeah, this is the wrong case to litigate ICPC. And there's just simply no way she can argue that but for the ICPC, the judge would have granted custody to this parent, a parent who can't even bother to come, a parent who says, I have no parental duties when my phone is broken. I mean, there's just no way the court would have trusted this father to take care of this child. So if there
Well, on that point, Ms. Pierce, I mean, we do have facts in this case that are a little bit different than some of the cases we see, in that the children lived with the father for a period of years. They were in his custody for quite some time. And that's something we don't often see. So, I mean, he's coming to this with a little bit of history of caring for the children. What do you make of that? And does that matter?
Well, it definitely matters. And you have the father's testimony of what that experience was like, and you have the child's testimony of what that experience was like. And the father's trying to say, I was a very capable, fit parent, and the child is saying something very different. So yeah, and those are all facts. So this is a fact-sensitive issue, and your question points that out. And so the judge would be pursuing those factual issues. And so it's a judicial decision whether or not to place the child in this situation. And at a minimum, the father would have to show that he complied with the service plan. So if there's no other questions, I ask this court to please respect this child's wishes, this child's lived experience, and to affirm the termination order. Thank you for your time.
May it please the court, John Peterson on behalf of the state of Utah. I am unmuted, yes. Okay, I guess I'll start off with Judge Harris's question about the courtesy check. And I was actually looking at the ICPC Reg 3 this morning, because I was actually thinking about that issue. And then there is a thing called a courtesy check. If you look under Regulation 3 under sub 3B, it basically it says that essentially the court, if you want to do a courtesy check, the judge here basically assumes all responsibility. They have to find somebody to do it. They basically assume responsibility for that being done right and done well, which is not that easy. I mean, it basically means the juvenile court judge here has to find somebody that they can trust in Louisiana. Whereas if you go through the ICPC, you're going through the Louisiana version of DCFS, I mean, which is presumably competent. And also, if it's under the ICPC, then you have the continuing cooperation of the state of Louisiana. Whereas essentially, if you do it behind their back, then you're kind of hung out to dry. You just have to assume that things go well in Louisiana.
So what you're saying is if you want to do something less than a full-blown ICPC home study, you have to go outside the auspices of the ICPC. In other words, ICPC, the Louisiana DCFS folks, if you submit a request to them under ICPC, they won't do anything short of that.
Yes, that's my understanding. I mean, it may be that they'd be willing to do the courtesy check, but I don't. I mean, my reading of the Reg 3 is that is not the way. I mean, if you want them involved, they want to be involved all the way. And I guess the other thing I would say that, to my mind, it doesn't really make, whether you call it a courtesy check, whether you call it an ICPC, whatever, it doesn't make much difference if you call it because it never happened. I mean, I think Ms. Pierce did a good job in her brief at page 1112, setting forth all the contacts they had with Louisiana DCFS. And like everything Father did in this case, he was just never available. His phone's broken, he's busy, he's at work. They tried many times, they never made it out to his house. So, I mean, to my mind, it doesn't really matter whether that was DCFS, whether it was a private investigator, whether it was a friend, whether they flew a DCFS agent out to Louisiana, when he's simply not making himself available to allow this to happen. And that's somewhat par for the course in Father's life. I mean, as I know, these proceedings no one's discussed. This goes back to 2010. This is the second time this family came under juvenile court jurisdiction. So, while Father may have been in and out of the children's life, he's not been a very stabilizing force in their life, obviously. And that, and again, that time Father's paternity has been a question since the 2010 proceedings. He's never gone to the trouble. I mean, everybody's kind of presuming that he's the actual father of KS, but he might not be. We don't really know because he's never gone to the trouble to affirm and to demonstrate that he is actually the biological father of KS. And so, I mean, I think as Judge Harrison noted, even if you were to find that the ICPC doesn't apply to a placement with a non-custodial parent out of state, it certainly applies to a placement of KS with him because KS isn't his child as a matter of law. KS could be, but he's never established that. And I mean, so I'd say that, I mean, what the court did, well, the court used the ICPC, that was a tool available to it, but it doesn't seem to be under the facts of this case that it particularly matters which tool the judge chose when there was simply no compliance and no assistance from the father in ascertaining what was going on. And as Ms. Pierce noted, it's not a case where this guy seems like, oh, he's out there and he may have been non-custodial, but there's nothing really wrong with them. I mean, the kids have been under juvenile court jurisdiction twice. And they testified pretty forcefully that he's an abusive person and they have no good memories of being around him. I mean, and under those kinds of circumstances, the judge would have been horribly remiss if he had not taken some kind of investigation and looked into the allegations of his home to see whether this is a suitable placement or not. Help you at all, Judge Harris, on the issue of the courtesy check?
Yes, thank you.
Okay, and I guess I'll turn just briefly to the question of counsel. I think it's been fairly well discussed, and as Judge Harris noticed, there are basically two options. You can do a colloquy, or you can ask to file an affidavit. I mean, and there may be very good reasons why this judge believes that the affidavit is the better approach. Maybe there's been a bunch of cases where the court's been burned and they've asked a bunch of questions and counsel said, no, I've been unemployed, I have nothing. You come back a couple months later, you find that he makes $50,000 a year and he really wasn't entitled to counsel. Whereas, I mean, if you actually make somebody go down and fill out, a simple, I think it's about a one-page form, this is my job, this is my income, and you really go through the work there, then maybe there's more chance that you're getting a good decision. I mean, and as Judge Harris noted, the statute, I mean, the rule gives you that option. And is choosing one or the other a constitutional deficiency? Probably not.
Mr. Peterson, might it be the case, though, I was quite impressed with the explanation. No, it seems like a simple thing. We're going to email you the form, you're going to print it, you're going to fill it out, you're going to scan it, you're going to send it back. Would a juvenile court judge deciding whether in a particular case best to have a colloquy in court or best to go the route of the form? And I take your point that no, a form is more reliable, it's signed, a little weightier kind of way to go about it. You can't just casually toss out your income. You're going to have to think about it and sign as to its truthfulness. So even appreciating those advantages, should a judge in deciding which way to go make some inquiry about, are you able to access a form online? Do you have the ability to print it and submit it either via scanning or through some other method? And if that person says, no, I haven't got a printer, I've only got a phone, I don't know what you mean by scanning, it might be more logical in that case to have the in-person colloquy rather than just out of habit say, we're going to send you a form, send it back, and we'll think about this council business later.
I mean, practically speaking, I mean, it makes some degree of sense, but I mean, if you're adding, colloquies about people's relative degree of like computer literacy, I mean, I don't know. It seems to be, I mean, well, it seems reasonable. It's also adding quite a bit of complication to, I mean, that could be applied to almost any sort of thing in this case. And the fact also remains that the father, voluntarily waived his right to counsel on 2 occasions. I mean, and granted, it's important, and as Ms. Harding noted, many people are not very sophisticated, but I mean, if you accept her argument, it would essentially mean that you don't have the right to waive your right to counsel, and you clearly do have a right to waive your right to counsel. And in this case, he did that twice. I mean, we don't have transcripts of those proceedings, so we have, all we're left to do is presume that the judge did tell him his rights and that he, knowing and voluntarily waived them, as the court, found in its written minute entries. And so, given the fact that he waived his counsel twice, maybe it wasn't that important to him to get counsel. Maybe it should have been important to him, but maybe he didn't really think it was. I mean, again, we're left with a lot of speculation about what father's motivations are in this case, based upon his lack of ability to do much of anything. I mean, is that helpful, Judge Orman? I see actually my time just went out.
Yeah, it is. Thank you. Ms. Harding, you have the last word.
Okay. The Guardian said, no one ever asked for a courtesy check in this case. And I just wanted to explain to the court that I've been full-time in juvenile court since 2009. I've never seen a courtesy check or a courtesy check requested or ordered by a court because every court does an ICPC. If you've got a parent in another state, you do an ICPC, period, the end. That's why we need help with this issue, because it's adding months and months and months of time to these cases where parents with parental rights do not get their children placed with them. We certainly understand there has to be a background check. You have to.
I'm sorry, I forgot to raise my hand. So is it implicit in the point you just made that if we were to conclude that on the facts of this case, failure to have ordered or not done an ICPC, no prejudice, it wasn't going to affect the outcome, it would still be helpful for practitioners for us to weigh in on whether the ICPC requirement across the board applies in the case of out-of-state non-custodial parents.
Yes, it comes up in every single case. I mean, some attorneys, parental defense attorneys, have given up. They know it's going to be an ICPC. Some of us are arguing, but we're going to lose. We lose every time because de facto, it has been decided that the ICPC applies. Even though a lot of us believe by its terms, it clearly does not.
Well, let me ask you, do you agree with what's been said that a courtesy check would be outside the auspices of the ICPC, or is a courtesy check a different option under the ICPC?
I think it's a different option under the ICPC, but frankly, none of the attorneys here, we don't know. So I'm the only one who's in juvenile court, but I don't work for DCFS, so I don't know exactly how that part works. I just know that there's a courtesy check out there and we're never allowed to use it.
So,
and we would like to.
Again, all we have here is the minute entries. of the early hearings. We certainly have the transcript of the trial. And in the minute entry, what the judge said is he's ordering, quote, an expedited ICPC, end quote.
Right.
And so if a courtesy check is also something that is available under the auspices of the ICPC, and he uses the word expedited, how do we know what he meant? I mean,
That's a term that exists. You can expedite an ICPC for certain conditions.
Yeah, but you just said it there, an ICPC. Well, that's a term of art, right? The ICPC is a statute. It's a compact. So you're ordering you're ordering a compact?
That's what we call it.
I
We call
realize
it an ICPC.
But what you're saying is there's a difference between two different things under the ICPC, and I think the situation calls for a little bit more precision in terms of terminology. So when he says expedited ICPC, what you understand him saying is an expedited home study, not something short of a home study that can be done faster.
Correct. Courtesy check is different from an ICPC, which we call the home study, the whole thing. You can expedite that process for really young children. There are other circumstances for expediting the ICPC.
And does it make a difference to you that the judge was concerned about the timing element of this and ordered an expedited ICPC?
No, they're still slow. They can still take months. I mean, I had another case with an expedited ICPC. It went on for like 5-6 months. And finally the judge said, I'm giving custody to the grandparents in the other state because we can't wait on this ICPC anymore. They're a real issue in juvenile court.
Here, Ms. Harding, don't you also have to acknowledge that there are fulfillment requirements by the parent, right? And that as was articulated in the guardian ad litem's brief, father here didn't necessarily make it easy to complete whatever process was implemented. Father didn't maybe necessarily fulfill his part of that program.
That is true, but he also didn't have an attorney. And for example, I'm an attorney who also has a social worker working with me, and I would have assigned a social worker to him to help him get it done. So not having an attorney, he was kind of floundering on his own, trying to get the thing done.
Okay, thank you, Ms. Harding. Mr. Peterson and Ms. Pierce, if you'll join us briefly back on screen. I had said Ms. Harding would have the last word, but I guess actually I will have the last word, which is merely to indicate for the record the unsurprising news that we will not be ruling from the virtual bench. We will take this matter under advisement and prepare an opinion, which we will issue as soon as we're able to get that taken care of. And we very much appreciate the arguments today. They've been helpful, at least to my understanding of the case, and I assume that of my colleagues as well. So thank you for spending your time with us this morning. And with that, we'll be in recess.
Thank you.